Welcome to our clients and friends. This is Bill Martucci. So thankful to be with you with my colleagues John Barkett and Ruth Anne French-Hodson. Of course, this is our annual Supreme Court program, the Roberts Court, 2018 to 2019, avoiding the limelight after the Kavanaugh-Kennedy trade. Well, a brief introduction to John and Ruth Anne. You certainly know them both from other efforts, but just a few words. John Barkett is remarkable as a human being and as an extraordinary lawyer. He's done so many great things in his career, and he continues to do so. And Ruth Anne and I are particularly thankful to him for all his hard work and his exceptional article that we have as part of the materials. As you probably know, John's a graduate of the University of Notre Dame, where he was Phi Beta Kappa, and Yale University Law School. He has served in recent years, for 7 years actually, on the Advisory Committee for the Civil Rules of the Federal Judicial Conference. It was at the invitation of Chief Justice Roberts that he served, and a number of the issues he dealt with would have included those revisions that we know so well that occurred with respect to the Civil Rules of Federal Civil Procedure, but also, ever more specifically, discovery rules, Rule 23, and more recently his work focused on Rule 30b-6 and MDL issues. So really fascinating aspects. He's also served for 3 years on the American Bar Association's Standing Committee on Ethics and Professional Responsibility. And those years overlapped with the service on the Civil Rules Committee. So truly, he has helped those of us who are American lawyers both on civil procedure rules in the federal courts and on ethical rules as it applies. Quite remarkable, truly. Ruth Anne is a graduate of the University of Kansas and Yale Law School. Between her time at the University of Kansas and Yale Law School, she studied at the University of Oxford, and her commitment to pro bono work has been exceptional over the years. Like John, she clerked at the appellate court level. John clerked for the old Fifth Circuit. Ruth Anne clerked for the Second Circuit. So we have two really bright light lawyers in the national prominence to address issues. John and Ruth Anne will go through a variety of topics, and we can raise questions through the question and answer box. So if you look at your screen, you'll see at the bottom right part of your screen a question and answer box. We'd be delighted for you to utilize that. And with that, without any further ado, John, would you start us off with a tribute to Justice Stevens?
I will indeed do so. Won't spend a lot of time on this, but good afternoon or good morning, depending upon where you are. To everyone, thanks for joining us. We just thought we'd say a word on Justice Stevens since he just passed away, 6 weeks ago. And you can see on the screen that he was appointed by Gerald Ford and retired in 2010. I had forgotten before we prepared for this that he had written the Chevron case. That's obviously going to be the focus of a court opinion. I'm not so sure this coming term, but at some point in the next 2 or 3 terms, I expect the Chevron opinion to be revisited. Apprendi, a very significant sentencing decision. Massachusetts versus EPA, which was a fascinating case in part because of the way that he secured Justice Kennedy's 5th vote to uphold a determination under the Clean Air Act that it indeed reached CO2 emission, but it was a states' rights sort of approach that he added to his majority opinion, and Justice Kennedy was a states' rights guy. That always seemed to be what most commentators suggested was the reason why he was able to get Justice Kennedy's vote in that very significant Clean Air Act case. Among his notable dissents, Bush v. Gore, the Second Circuit, the Second Amendment decision in Heller, and then, of course, the First Amendment decision in Citizens United. So from law clerks of his that I've spoken with, always described as an absolute gentleman. I heard him speak only one time And he was very warm in a reception line afterwards. Gracious guy, obviously a distinguished career, and we will miss him. Let's talk a little bit about some statistics. People are surprised sometimes to hear that while there were 25 vote majority cases this term, 8 of them went the way of what I will call the liberal bloc. And you can see the Chief Justice joined in 2 of those cases, providing the 5th vote. Justice Alito in 1, Justice Gorsuch in 2, plus 1 more concurring in the judgment. Justice Kavanaugh 1 and Justice Thomas 1. 7 by the conservative bloc and 5 with other combinations. So the title of my paper, Avoiding the Limelight, is probably consistent with these set of numbers as well, because it was a quiet term and a challenge for me in drafting this year to write about cases that I had no real interest in, but have to try to explain. But I think that also is part of the reason why the liberal bloc, conservative bloc distinction perhaps isn't that material in some of the 5-vote decisions. But you can look through the paper and get a sense of it. And we'll talk about several of the cases as well. You'll see that a lot of consensus, 45% had 8 or 9 votes. And interestingly, Justice Kavanaugh had the fewest dissents, even accounting for the 7 decisions in which he did not participate. Now, some of you may know that Justice Kavanaugh clerked for Justice Kennedy, and Justice Kennedy traditionally wrote the fewest number of dissents. And it looks like Justice Kavanaugh is going to follow in his footsteps. We'll talk about him in a bit more detail in a second. And if it's okay with you, Bill, I'll just move on to the first substantive case that we're going to discuss.
That sounds great, John. And the conversational way you're going about this is wonderful, truly.
Okay, very good. And again, if you have a question, don't hesitate to type them and we'll try to react to them. So you'll see 3 slides here on what I call the Chief Justice's trilogy. I'll discuss 2 of the cases and Ruth Anne will discuss 1 of them. But the first one is the one that got the most attention. This is the citizenship question case. And I commend to your reading the Chief Justice's opinion, because as many times as I read it and in drafting my discussion about it, it looked like you kept reading and you kept saying to yourself, the Department of Commerce, the government's going to win, the government's going to win, the government's going to win. And all of a sudden you get to the last part of the opinion and the government lost. It's a very interesting contrast. The way the vote counts worked, you literally needed a scorecard for each part to figure out which justices were joining and which parts of the opinion. But essentially what the Chief Justice explained is that the citizenship question was on the census every 10 years until 1950, going back to the early 1800s. So in asking the question wasn't that novel, but over time, because of administrative regulations that required registration of aliens and the ability to count non-citizens through that administrative tool, and because of the development of statistical analyses, the question was only asked, the citizen question was only asked to a percentage of the population every 10 years, and then extrapolations were made. Over time, the issue of a concern about whether folks would answer the census if the citizenship question was on there sort of overtook the Census Bureau, and they highly recommended that the question not be asked in order to get a decent count. As you know, the facts, those of you who have read anything about the case know that the Secretary of Commerce Wilbur Ross was found by the district court judge to have essentially lied about the reason for the question being on there. The documentary story was pretty clear that he came up with the excuse that this was necessary to allow the Department of Justice to enforce the Voting Rights Act. The document showed that the Department of Justice never sought that. It was the secretary who proposed it to the department and then made it look like the department was seeking it. Interesting from an Administrative Procedure Act perspective to see how Judge Furman, the district court judge, ordered extra record evidence, very unusual in an APA case where you go beyond the administrative record. But in this case, because the government submitted some documents late, it raised a question about whether there were other documents that weren't submitted. That ultimately led to a motion and an order. One of the questions the Chief Justice had to answer was whether or not you could look at the entire record in rendering a decision. Chief Justice held you could. But then interestingly determined that Judge Furman was wrong in concluding that Secretary Ross didn't have a reasoned basis to require a citizenship question. The explanations were pretty straightforward. Hey, maybe that administrative regulation and the list that it's supposed to be created of registrants, alien registrants, maybe it's not comprehensive enough. Maybe the statistical analysis won't be accurate enough. So why not just get a good count and ask the question? And Judge Furman, based on the facts, thought that the Census Bureau's experts should be believed. But the Chief Justice said that, look, hey, you're just substituting your view for that of the secretaries, and that's not appropriate under the Administrative Procedure Act for a judge to do that. But then the very last part of the opinion is where the Chief Justice essentially said, he didn't use the word lie, there was a mismatch between the explanation and the facts, and he used the word contrived to describe the explanation. And he did his best to cabin the decision to the facts of this particular case. But for anybody who does administrative procedure work, APA work, administrative law work, the opinion will be one that will be used whenever a plaintiff believes that the plaintiff can show that the bona fides of the decision can be undermined. And essentially, that's what the Chief Justice held here, is that you need a reasoned explanation, a substantively valid explanation in order to test the explanation. And here, to use the Chief Justice's words, I'll read the last sentence. Reasoned decision-making under the APA calls for an explanation for agency action. What was provided here was more of a distraction. So I'm not sure quite what that means, but the case was remanded to the Census Bureau, to the Department of Commerce. There wasn't enough time for the remand to result in any change, even though the president attempted that for a short term, eventually abandoned the idea that they could use part of the opinion to try to justify the question. And pretty soon we'll see I'll get the census questionnaire without the census question on there. So let's go to the second part of the trilogy, Ruth Anne.
Thanks, John. As previewed by John, the case that I'm going to be talking about is the Common Cause case, and it was another highly anticipated case of the term. For decades, the Supreme Court has been splintered on the question of partisan gerrymandering and how to handle those cases. For non-political junkies, these cases have to do with the redistricting process. In most states, the state legislatures draw the lines that determine the districts or geographical areas from which those same legislators are elected, and also the lines that define what areas elect members of the House of Representatives, the U.S. House of Representatives. This process has now become quite sophisticated. You have political consultants that rely on big data, computer models, mapping, and they can draw the districts to virtually ensure, in some cases, that candidates of the party with the majority in the legislature will be elected by the voters within that district. And this is done by, as I said, these computer models that can carefully select voters for the district right down to carefully drawing lines block by block and splitting strongholds of the other party into multiple districts, even if they're in the same city or area, to dilute the political power. In one of the cases that the court was considering, they were looking at the North Carolina plan, and the legislator had chosen a plan that was not so subtly labeled the partisan advantage plan to elect Republicans. And unsurprisingly, the plan worked. In 2016, Republicans won 10 of the 13 U.S. House seats, even though they only got 53% of the vote statewide. And in 2018, they got 9 out of the 12 House seats with only 50% of the vote. This isn't one side or the other. Similar results were accomplished by Democrats in Maryland in the other challenged map that was before the court. This process of drawing these lines to favor a political party has been labeled for almost 2 centuries now gerrymandering, a somewhat funny term. The gerry comes from an 1812 effort by the governor of Massachusetts at that time, Elbridge Gerry. And the mander refers to his political opponents who said that his districts resembled a salamander and not a nice consecutive district. In the Common Cause case, all of the justices recognized that gerrymandering was incompatible with democratic principles and had led to results that the Chief Justice termed or said was reasonably seemed unjust. Now, this is not a new phenomenon. Not only is this not a new phenomenon, it's not the first time it came before the court. In 2004, Justice Kennedy had suggested in a swing vote in Wyeth that he believed that partisan gerrymandering was a justiciable question, but at the time there was just no judicially manageable standard for determining whether political tinkering was within the acceptable bounds or went too far. Because Justice Kennedy had held out hope that at some time a standard could be developed, he was unwilling to foreclose the possibility of adjudicating these political gerrymandering disputes. But when the court decided Common Cause in 2019, Justice Roberts for the majority was decisive this time and held that the lower federal courts did not have jurisdiction to take the action that they did, because partisan gerrymandering does not present a case or controversy within the meaning of Article 3 of the Constitution. Justice Roberts took a historical approach to get here, and he emphasized that the inclusion of politics in the districting process was both normal and expected. And while he spent a section at the end of his opinion recognizing the ills of gerrymandering, he decided that there was no way to determine what amounted to too much political influence. No door was left open, in his opinion, as Justice Kennedy had done 15 years previously, and foreclosed that federal courts could find a way in the future to identify and correct the ills of political gerrymandering. Now, this decision was harshly criticized by the liberal wing of the court. Justice Kagan penned the dissent. She also read the dissent in its entirety from the bench when the decision was announced, and that was a rare occurrence at the court. While I cannot hope to convey her conviction, I wanted to just read the first paragraph of her opinion, which John also put in his kind of compendium on decisions, because I think both of us agree that it really powerfully captures the essence of her disagreement with the majority. As she writes, for the first time ever, this court refuses to remedy a constitutional violation because it thinks the task beyond judicial capabilities, and not just any constitutional violation. The partisan gerrymanders in these cases deprive citizens of the most fundamental of their constitutional rights, the rights to participate equally in the political process, to join with others to advance political beliefs, and to choose their political representatives. In so doing, the partisan gerrymanders here debased and dishonored our democracy, turning upside down the core American idea that all government power derives from the people. These gerrymanders enabled politicians to entrench themselves in office as against voters' preferences. They promoted partisanship above respect for the popular will. They encouraged a politics of polarization and dysfunction. If left unchecked, gerrymanders like the ones here may irreparably damage our system of government. End quote. I should note that Justice Roberts did not ignore the necessity of some action, but unlike Kagan, he didn't believe that the Supreme Court should be the one taking the reins and correcting the ills of political gerrymandering. For the majority and Justice Roberts, the solution lay in the states, either with state legislatures themselves, or through the creation of independent commissions, or through state court enforcement of state constitutions and statutes. Justice Roberts had noted that the Supreme Court of Florida had previously struck down a congressional districting plan under that state's unique Fair Districts Amendment to their constitution. Justice Kagan, in contrast, was highly skeptical that state legislatures that benefit from the current system would step in to police themselves. And as to state courts, Justice Kagan pointed out the irony of recognizing that state courts could find a judicially manageable standard while holding that federal courts couldn't. We have already witnessed a movement of the fight to state courts, and it looks like we already have a question, I believe, about this movement. Just last Friday, as several of you might have realized, a North Carolina state court held that the North Carolina's district maps were unconstitutional under that state's free election clause, which required that all, and I'll quote, all elections shall be free, and that is the standard in which they then proceeded to find that political gerrymandering violated that provision. The Republican-led General Assembly must now submit redrawn state House and Senate district maps, and those will be reviewed by a court-appointed referee. And Common Cause has made, no small question. They will now proceed on a state-by-state fight on this partisan gerrymandering fight. And John, I don't know if you want to add anything on this.
Everything that I've read, and I think that the fight will be taken to the states, and you will see other arguments raised in federal court. The issue is not going away by any means. But why don't we move to yet another one of the trilogies? This involves an overruling of a case, the Williamson decision, as you can see on the screen, and the San Remo Hotel decision. I don't know how widespread this opinion is going to have an impact. I was talking to a county or city attorney not too long ago who said he was actually happy with the decision because he preferred to be in state court. Preferred to be in federal court, not in state court anyway. But let me just walk you through the facts, and then you'll appreciate what the case is about. So the township in question passed an ordinance that required cemeteries to be open to the public during business hours, in effect. And Nick actually had a cemetery on her property. I don't know that many people have cemeteries on their property, but she lived on 90 acres of land north of Scranton, Pennsylvania, in a place called Scott Township, and she had a family cemetery. And an inspector noticed the cemetery and said, "You're violating the ordinance because it's not open to the public." She took issue with that. The township brought an enforcement proceeding. When she responded by suing the township, claiming in state court that there was a taking of her property, the township withdrew the enforcement proceeding. The state court judge then decided not to consider an injunction request because the state court concluded there couldn't be irreparable harm if there was no enforcement proceeding. So what does Nick do then? She files a Section 1983 claim in federal court seeking damages for a violation of the Fifth Amendment takings clause. For those of you who aren't aware of Section 1983, it essentially allows, it's a statutory vehicle to bring a claim for damages for a violation of a constitutional provision. You see a lot of 1983 claims against police officers for example, excessive force. But this is one where you have a Fifth Amendment claim, and but she lost. And why did she lose? Because of Williamson, which said if you want to bring a takings claim, you have to exhaust your state court remedies first. So you must file in state court, bring an inverse condemnation claim. And then San Remo comes down and says, well, if you lose in state court following Williamson, then you can't bring a federal claim because you've already had your chance to recover and you lost. Now, William Rehnquist was the Chief Justice in a decision called First English, written many years ago, and he had suggested that even though he had joined in Williamson, that the decision was probably wrong and ought to be revisited. The Chief Justice was a Rehnquist clerk, and it's not surprising that when he had the opportunity, he took it to overrule Williamson, essentially saying, hey, look, the Fifth Amendment deserves the same attention that every other Bill of Rights amendment deserves. You should be able to bring a 1983 action without having to go to state court first. Why would this be different? The claim is perfected upon the taking. It doesn't lose its status as being a claim because you should go to state court first. Exhaustion doesn't appear anywhere else in 1983, so why should it appear here? There's a stare decisis component to this case, which I'll talk about a little bit later once we get to a discussion of stare decisis under the Roberts Court. But you should just simply note here that stare decisis wasn't enough for the court to maintain the Williamson decision. So going forward, again, I don't know if this is going to be a significant issue for municipalities and counties or not. The Chief Justice was quick to say governments don't have to be fearful that federal courts are going to be invalidating regulations as unconstitutional because there's a just compensation remedy available. Injunctive relief will be foreclosed. As long as a plaintiff can get compensated for taking, you can't enjoin the enforcement of an ordinance. And he also said you don't have to worry about courts setting aside acts under the Administrative Procedure Act because, again, under the federal system, you can bring a claim, a Fifth Amendment claim under the Tucker Act in a court of claims. So effectively, he said the dissent's concerns were really unfounded, and the Fifth Amendment takings right stands, is immediate, and folks can bring actions against counties and states and municipalities and the federal government for that matter whenever they believe a taking has occurred. So interesting opinion. I'm not sure yet what kind of an impact it'll have because I don't know how many plaintiffs are lying out there waiting to sue counties and cities who aren't also prepared to bring inverse condemnation claims. But now they don't have to do that. They can file in federal court under 1983. Let's move to some First Amendment cases. Ruth Anne, you want to take over?
Yeah, so we had two major First Amendment cases this year. The first that I want to discuss is American Legion versus the American Humanist Association. It was an Establishment Clause challenge, and it was to a rather large 40-foot cross monument to those from that county who had lost their lives in World War I. It was known as the Bladensburg War Memorial. The cross had been built directly following World War I in 1925 by the American Legion. And in the 1960s, the local Park and Planning Commission acquired the cross and the land it sat on for preservation and traffic safety purposes. Now, on that kind of brief description, you may be asking yourself why the court was just now hearing a challenge to this cross monument that had existed for over 90 years and which had been maintained with public money for almost 60 years. Well, you would not be alone in asking this question, and this theme runs throughout Justice Alito's opinion. As he notes, the passage of time since the 1920s makes it almost impossible to determine the motivation of those responsible for the design and construction of the monument. He then did a historical survey of what it would have meant at the time, and also noted the importance of the cross in World War I, including its use at Arlington Cemetery to commemorate those who fought in World War I. Justice Alito pointed out that World War I memorials across the country, like the Bladensburg Memorial, often function not just as monuments, but as almost like individual gravestones for families that could not travel to Europe to visit graves, or for soldiers whose bodies were never found or identified. The cross in cemeteries reminded us of the sacrifice given for the country by World War I soldiers. And similarly, that recognition of sacrifice did not change when the cross is used to memorialize soldiers on public property. Given the World War I cross's familiar place in the physical and cultural landscape, the majority of the justices held that its existence did not violate the Establishment Clause. Now, the vote was 7-2, and there was never, I think John would agree, much doubt about whether the Supreme Court would uphold the constitutionality of the public maintenance of the cross. What I think was surprising, especially seeing the 7-2 vote, was how fractured the court was on how to evaluate Establishment Clause cases. Now, John had referred earlier to needing a scorecard, and this was another one of those cases where you would need a scorecard as you go along through Justice Alito's opinion to identify which different justices were joining which different part and subpart of the case. Justice Alito's entire opinion was only a plurality opinion, with the majority only joining certain sections, and two of the justices, Thomas and Gorsuch, only concurred in judgment. As you may remember from your con law classes, the test that the court had applied since 1971 to Establishment Clause cases was called the Lemon Test, and that test had federal courts ask three questions. Does the challenged government action have a secular purpose? Second is, does it have the principal or primary effect of advancing or inhibiting religion? And does it foster an excessive government entanglement with religion? Now, none of the opinions that came out, because there were also many concurring opinions to go along with the plurality, none of those who would have voted for the majority gave a ringing endorsement to the utility of this Lemon Test. But there seems to be no unifying consensus on how to evaluate Establishment Clause cases going forward. That, as I mentioned, resulted in these multiple concurring opinions that set out various manners to look at these cases. Justice Alito, for one, spent a lot of time harshly criticizing the Lemon Test, and he was able to garner a majority for his criticisms of the test and the daunting problems in its application. But as to his proposal of how to look at Establishment Clause cases in the future, he could only garner 3 additional votes. Not surprising, given the tenor of his opinion, Justice Alito concluded that the Lemon Test should not be used, and instead there should be a presumption of constitutionality for long-standing monuments, symbols, and practices, like the one being evaluated here. But the Justices Breyer, Kavanaugh, Kagan, Thomas, and Gorsuch all penned their own opinions, offering alternative views on how to evaluate the constitutionality of this case. I think Justice Kagan was probably the closest to Alito in analysis, as she still recognized the problems with the rigid application of the Lemon Test, but she was unwilling to let go of its utility and having courts at least look at the purpose and effect of government action. And while she agreed with Justice Alito that history could be important, she would do it more on a case-by-case basis. For those who follow Justice Breyer, I think it would be unsurprising that he suggested there was no single formula for resolving these cases, but we should look just to the purpose of the Establishment Clause and evaluate cases as they come. interestingly, Justice Kavanaugh rejected the lemon test, but he did so by doing a real long survey of the Establishment Clause jurisprudence that's followed the lemon decision and concluding that, in fact, the court has never really followed that decision. And instead, he pulls out some principles that he thinks should guide the court in the future. I'll go quickly through the other two. Justice Thomas, again, maybe somewhat unsurprisingly, believes that the Establishment Clause should not be incorporated against the states. And Justice Gorsuch's opinion focused instead on standing and noted that these plaintiffs, we shouldn't even get to the constitutional question because you couldn't, the observers who were offended did not have standing to challenge the action. And there's no need to apologize if you didn't follow or take good notes on all of my concurring opinion analysis. The only thing that really remains clear, I think, at the end of the day at this opinion is that the Supreme Court's still coming to terms on how they'll evaluate these types of cases in the future. The court's other First Amendment case was not a religion one. Instead, it was a First Amendment speech case on viewpoint discrimination and came up in the trademark context. Eric Brunetti was a streetwear designer, and he had attempted to trademark his streetwear brand. I'm only going to spell the brand for you. It is spelled F-U-C-T, and I'm not going to sound it out phonetically, but because all of you are on mute, you can feel free to sound it out loud. No one will hear you. Given how it's said out loud, you may not be surprised to learn that when Brunetti sought to register his trademark with the Patent and Trademark Office, he encountered resistance because 15 U.S.C. Section 1052A prohibits the registration of a mark that consists of or comprises immoral or scandalous matter. In applying this statutory prohibition, the PTO looked at whether a substantial composite of the general public would find the mark shocking to the sense of truth, decency, or propriety, if it would give offense to the conscious or moral feelings, if it was disgraceful, offensive, disreputable, or vulgar. And in doing so in this case, the PTO examining attorney had determined that FUCT was a total vulgar and therefore unregisterable. And the appeal board similarly concluded that the term was extremely offensive. Not letting things lie, Brunetti decided to bring a facial challenge to this entire section of the statute. And Justice Kagan agreed that the facial challenge should succeed because she found that the immoral or scandalous prohibition in the statute discriminated on the basis of viewpoint in violation of the First Amendment. As she wrote, the statute distinguishes between two sets of ideas, those that are aligned with conventional moral standards and those hostile to them, those inducing societal nods of approval and those provoking offense and condemnation. And her hypotheticals, love rules and always be good would allow registration, but hate rules and always be cruel would fall against the immoral and scandalous bar. Now, several justices would not have gone so far as Justice Kagan went in accepting this facial challenge. For example, Justice Breyer would have barred the immoral marks prohibition, but he would have carved out a different approach for those marks characterized as scandalous. Additionally, multiple justices noted the possibility that Congress could go in and craft a more focused statute that would prohibit highly vulgar trademarks but remain viewpoint neutral. We'll watch and see whether Congress will step in to fill this void and whether any action meets the test set out by Justice Kagan.
Why don't I take over and return to administrative law? Again, an extraordinary decision in many respects because maybe even the Chief Justice couldn't stomach overruling 3 precedents in the same term. This case involved what's referred to as Auer deference, A-U-E-R deference, which means that a regulatory agency is entitled to deference if it's interpreting its own regulations. That's as opposed to Chevron deference, which refers to a regulatory agency interpreting a congressional statute. So here we're dealing just with an agency interpreting its own regulation. And a lot of folks were watching the case to see if the court overruled Auer and the Seminole Rock case, because that might have been an indication of the fate of Chevron. But the Chief Justice joined with the liberal bloc in concluding that our decision should not be overturned. This was not a 5-4 vote, but it's pretty clear to me that it's because of the outcome that it was a 9-0 decision. It's being remanded. Let me explain to you what happened, and you'll appreciate how the voting went. This is another one of the opinions where you need a scorecard again. Part 1 had 5 votes. Part 2A had 4 votes. Part 2B had 5 votes, and then on and on and on. But what's really critical is Justice Kagan's emphasis on the standard that has to be applied going forward. I'm referring to it now as Kaiser deference and not Auer deference. And she essentially sets forth the following rules. Number 1, a court should not afford Auer deference unless the regulation is, quote, genuinely ambiguous. That phrase is used 6 times in the opinion. Genuinely ambiguous. Rule number 2, before concluding that a rule is genuinely ambiguous, a court must exhaust all the traditional tools of construction. Rule number 3, if genuine ambiguity remains after exhausting all the tools of construction, the agency's reading still must be reasonable. In other words, it must come within the zone of ambiguity that the court has identified after employing all of its interpretive tools. And rule number 4, not every reasonable agency reading of a genuinely ambiguous rule should receive Auer deference. So what's the upshot of all this? As Justice Kagan explains, when it applies, Auer deference gives an agency significant leeway to say what its own rules mean. In so doing, the doctrine enables the agency to fill out the regulatory scheme Congress has placed under its supervision. But that phrase, when it applies, is important because it often doesn't. As described above, this court has cabined Auer's scope in varied and critical ways, and in exactly that measure has maintained a strong judicial role in interpreting rules. What emerges is a deference doctrine, not quite as tame as some might hope, but not nearly as menacing as they might fear. So to put this in perspective, the Chief Justice wrote a concurring opinion in which he says, hey, look, there's really not that much difference between what Justice Kagan is saying and Justice Gorsuch is saying. Now, Justice Gorsuch, he would have overruled Auer and would have invoked a case called Skidmore versus Swift and Company, which was a 1944 decision that held that an agency's interpretation of its own regulation is simply a matter of evidence. It may be persuasive, but it's not entitled to deference. And in Justice Gorsuch's view, the Skidmore rule is what should apply, that whatever the agency presents can be considered as a matter of evidence, but not deference. That, by the way, I'm sure is also his view on Chevron deference, but that case hasn't come down yet. But what the Chief Justice said is, when you look at what Justice Kagan wrote, you take a look at whether or not the agency's interpretation is reasonable, whether it reflects an authoritative, expertise-based, and fair and considered judgment, and whether the agency is taking account of reliance interests and is avoiding unfair surprise. And when you look at what Justice Gorsuch is proposing, The reasons he writes that a court might be persuaded, as opposed to deferring, might be persuaded to adopt an agency's interpretation is that the agency thoroughly considered the problem, offered a valid rationale, brought its expertise to bear, and interpreted the regulation in a manner consistent with earlier and later pronouncements. And so he concludes, accounting for variations in verbal formulation, quote, those lists have much in common. So that's, I think, is another way of saying I'm not going to, in deference to stare decisis, I'm not going to see yet another overrule of a major case in this term when Justice Kagan was able to come up with an opinion that worked, but still was strong enough to tame, to use her words, to tame agency interpretations of its own regulations to secure the Chief Justice's vote and to get a concurrence in the judgment from the other justices. What's the implication of this case for Chevron deference? The Chief Justice was very quick to write that issues surrounding judicial deference to agency interpretations of their own regulations are, quote, distinct from those raised in connection with judicial deference to agency interpretations of statutes, citing the Chevron. And then he writes, I do not regard the court's decision today to touch upon the latter question. Well, I have to tell you, there are so many citations to Chevron deference in Justice Kagan's opinion that I'm not sure that when he writes that he doesn't regard the decision as touching upon the latter question. Certainly, several of the other justices, I think, viewed it as very similar, but he was giving himself some cover in case he reaches a different result in a Chevron deference opinion that I'm sure is going to reach the court, as I said before, probably within the next 3 years. So with that, why don't I stick with the topic of stare decisis? Oh, wait, are we going to talk about the death penalty next? Oh, stare decisis, yes. So I promised I would say a word about it. What is the view of this court on stare decisis? You haven't heard about the Franchise Tax Board case, but that was Justice Thomas's opinion, overruling a case called Nevada versus Hall. You've heard about Nick, the Chief Justice's opinion overruling Williamson. I've just told you about Kaiser, where there was clearly a reluctance to overrule Auer, even though if the Chief Justice had joined with the conservative bloc, that would have happened. Auer would have been overturned if he wanted to make that happen. He clearly didn't want to make that happen. But then in a case called Box versus Planned Parenthood, it was a per curiam opinion upholding an Indiana law dealing with the disposition of fetal remains, allowing for cremation of those. In that particular case, the claimants, the plaintiffs, had argued for a rational basis standard. And under, if you remember the Planned Parenthood versus Casey decision from several years ago, the decision jointly written by Justices Kennedy, Souter, and O'Connor, pretty sure that was Souter, but the three of them wrote the opinion. And in it, they established this concept of the undue burden on a woman. And that was an effort to overrule Roe v. Wade. And that case suggested that a standard a little bit higher than rational basis was appropriate. But that argument wasn't made in the Box case. And so the court deals with it on a per curiam basis. And then in the G decision, very significant case, again, for the court. They'll see it probably either this coming term or next term, but there was a motion to stay a Fifth Circuit decision that would have eliminated all abortion clinics in Louisiana. A lot of people were watching to see what the Chief Justice would do, and he provided the fifth vote to issue the order granting the stay. So does stare decisis mean what 5 justices think it means? Or does stare decisis have some greater meaning? If you take a look at Justice Thomas's opinion in the Franchise Tax Board case, he has a quote in there from an opinion written by Justice O'Connor dealing with Title I of an education bill providing funding for teachers that, in that particular case, were involved in parochial schools, separation of church and state type of case. And she wrote in that opinion that when you're dealing with an interpretation of the Constitution, that stare decisis is at its weakest. And I'll read what Justice Thomas wrote. Stare decisis is not an inexorable command. We have held that it is at its weakest when we interpret the Constitution, because our interpretation can be altered only by constitutional amendment. But when you go back and look at this case that he cites, Agostini versus Felton, it's a 1997 decision that itself overruled 2 1985 decisions. When you look at Justice O'Connor's analysis in that case, she says that there were several intervening decisions which sort of set the table for Agostini to come down. And it reminded me of what the court did in overruling the Abud decision, the decision involving public unions and the payment of fees for union activity, that the court finally overruled the Abud decision 2 terms ago. But they got there through 2 prior opinions by Justice Alito, sort of setting up the final decision overruling the Abud decision. And that was a case called Janus versus State, County, and Municipal Employees. And the factors in that case, there are 3 of them: the quality of the reasoning, the consistency with related decisions, legal development since the decision, and then there's yet another case Justice Thomas decided that focuses on reliance. And those seem to be the 4 factors: quality of the decisions, reasoning, consistency with related decisions, legal development since the decision, and reliance, that certainly Justice Thomas would follow. The Chief Justice, I think, is a bit more guarded. He invoked those same rules in his opinion overruling Williamson, but he did it by using the word including and not saying these are the factors. Justice Thomas was a bit more firm in deciding what the factors are. But if you look at Justice Breyer's dissent in the Franchise Board case, he cites from another line of cases on stare decisis. Both he and Justice Kagan used the same phrase, and Justice Kagan in our, Justice Breyer in his dissent in the Franchise Tax Board case, that overruling a case always require, quote, special justification, close quote. And he says that the majority didn't have one, and suggests that the only reason the Franchise Tax Board was overruled is because 5 justices decided it should be overruled. A very terrifying view of stare decisis. So what does all this mean for Roe v. Wade, which is always the elephant in the room? Do we get any indications, for example, of Justice Kavanaugh's views here? Hard to say. He, in the June medical decision case, the stay case, he actually cited to the undue burden standard and suggested that, in fact, abortion clinics would be able to stay open in Louisiana even if the stay hadn't been granted. He joined in the per curiam opinion in the Box case. So hard to know what his views are, but I think it's safe to say, and I would encourage you to go back and reread what I did earlier today, the Casey decision from 1993, I think it was. There's a wonderful discussion stare decisis, because, of course, Roe was on trial in that case. Roe v. Wade was on trial in that case. And I think it's safe to say that you are not going to see an overrule of Roe v. Wade in an instant. It's not going to be a case comes up and it's just automatically overruled. If this court ever gets there, and that's a big if, because I think the Chief Justice is very concerned about the court's legitimacy, and overruling Roe, and certainly in this political environment, might suggest that the court is just like the other two branches of government, driven by politics. Chief Justice is very jealous of protecting the court's reputation. But I would encourage you to go back and read the discussion of stare decisis in the Casey case, because it really emphasizes the importance of protecting the court's legitimacy in our constitutional democracy. So I'll leave it at that, so we can talk a little bit about the death penalty cases, which were numerous this term, Ruth Anne, and clearly the court has different views.
Right, and while there are definitely differing views, represented in the cases that we saw come down, I think there's also pretty consistent in the rulings. The death penalty itself, I don't think there's any question of whether it's in jeopardy or not. There's, firmly a majority that finds the death penalty constitutional, and really only Justice Breyer has staked out a hard claim against the death penalty. I think it's unclear even whether some of the rest of the liberal wing of the court, like Kagan or Sotomayor, would join Breyer on such an opinion. This term did highlight what I think we would call some of the very morbid aspects of death penalty jurisprudence and the burden that the court is willing to put on those sitting on death row. For example, in the Bucklew case, the court put the burden on death row inmates to find a less painful way to be executed. Petitioners that could not make that showing would be executed using the standard established drug protocols. However, the court has emphasized that they are open to, certain narrow avenues for providing relief from the death penalty, especially when egregious cases arise. One of the ones that John has highlighted up there is Moore v. Texas. That's a case that had been previously before the court in 2017. In 2017, the Supreme Court determined that the Texas Appellate Court had made multiple errors in determining that Mr. Moore did not have an intellectual disability that would bar the application of the death penalty. On remand, the Texas Court of Criminal Appeals reached the same conclusion. And again, Moore petitioned the Supreme Court. This time, he even brought along the support of the prosecutor from his county, who wrote an amicus brief that Moore is intellectually disabled and cannot be executed. The per curiam opinion agreed with the prosecutor, and this time they left no room for the Texas Court of Criminal Appeals on the question, and decided for themselves that on the record, Moore was a person with an intellectual disability. Another avenue for relief exists when prosecutorial misconduct is so egregious that it can't be ignored given Supreme Court precedent. This is another one, the first one that John has highlighted, Flowers v. Mississippi. There, the court considered the conviction of Mr. Flowers, who had been tried 6 times in Mississippi State Court on murder charges. In the first 3 trials, while they were all convictions, they were all reversed by the Mississippi Supreme Court based on prosecutorial misconduct or racial discrimination in jury selection. Then he had 2 mistrials, and then the last trial resulted in a conviction that was affirmed in a 5-4 vote. The same prosecutor had tried every one of the cases, and the Supreme Court considered whether that prosecutor also engaged in misconduct during jury selection in the 6th trial. As they noted, in the 6 trials combined, the state struck 41 of the 42 Black prospective jurors. And at the 6th trial, the state struck 5 of the 6. The Supreme Court found engaged in dramatically disparate questioning of Black and white prospective jurors and engaged in disparate treatment of Black and white prospective jurors. The majority opinion was penned by Justice Kavanaugh, and he emphasized that this case was not breaking any new grounds and was mandated by the Batson case. And he also emphasized how important it was to eradicate racial discrimination from the jury selection process, in part to enhance the public confidence in the fairness of the criminal justice system. So one thing I would emphasize is while the justices are concerned that the penalty is applied fairly and that people have confidence in the system, they have no hesitation in the application of the death penalty when they find the process fair. And I think just really briefly, I think both John and I are going to give kind of some quick highlights if we have time on our view of year 2 for Justice Gorsuch and Justice Kavanaugh.
Why don't we just move to that, Ruth Ann? Let's move to it. The other death penalty cases, you can read about them in the paper. They, unfortunately, in a couple of cases, the court decided not to block executions, and I believe Price was in fact executed. I'm not sure that Ray has been yet, but one of these two was executed a day after the court's refusal to block or to stay it. But let's talk about Justice Gorsuch. What do you think we've learned now after 2 full terms on the court?
Yeah, and I think looking at his voting record, and you set out in your paper some of the statistics, there is no doubt that Justice Gorsuch is firmly in the conservative bloc. But I would say that, like his predecessor, Justice Scalia, I think it's becoming apparent that there are certain areas where he will provide the 5th vote with the liberal bloc. I think we highlighted a couple of them earlier, but the kind of 3 areas that I think we saw that can garner his vote. One is in the criminal justice arena, and 2 of those opinions were, let's see, it's Haymond and Davis. Yep, okay, we've got them up now. In those cases, Gorsuch himself wrote the opinions, and he was joined by the liberal wing. He seems very concerned that due process, especially when you're going to take away liberty, means something. That was in the Haymond case, but in both of them, criminal defendants were facing longer prison sentences, and in the in the Davis case, he used unconstitutional vagueness to strike down what he found to be a statute that did not give enough notice to the criminal defendant on what was being forbidden and would give too much prosecutorial discretion. In Haymond, again, it was one in which he found that if you're going to sentence someone to an extra 5 years for a violation on supervised release, that has to be done by a jury and not a judge. So even if, these things that, even if our constitutional rights might become tedious or take up time, they are very important to the system, especially when you're going to take away liberty. And that's a real emphasis of his, and I think it comes out in both of those cases. The other place where Justice Gorsuch seems to have a pretty consistent view is in the Indian law jurisprudence that the court is developing. We've got 2 cases highlighted here, both Herrera and Cougar Den. I won't say much because I know we're kind of running short, but in both of them, Justice Gorsuch really emphasized that we should be reading treaties as he would suggest we need to read statutes. We look at what they originally meant at the time, how the tribes would have read and enforced them, and not just his criticism of those like Kavanaugh, who would read them with a lawyerly gloss by 21st century standards. And he was, along with the liberal bloc in both of those, in those cases. And then the last one, just really quickly, and it goes with the Religious Establishment Clause case as well. This is a standing decision, and that's another way to kind of garner his vote, I think, in the future, is kind of a narrow view on standing. I think those 3 themes come out for Justice Gorsuch at this time. I think that's all I'll say now, and I'll let you pass.
Sure, let me just say a word about Justice Kavanaugh, the newest justice. As I mentioned before, he had the fewest number of dissents. But interesting decision in Apple versus Pepper indirect purchaser rule under Illinois BRIC antitrust decision, where he joined with the liberal bloc. The issue, it was on a motion to dismiss, so the court had to accept the allegation that Apple was a monopolist. But I think he also planted Trojan horse in his concluding paragraph, where he referred not to the Apple app market, but the retail app market. But in terms of a direct purchaser, people that bought from the App Store in order to challenge Apple's charging developers of apps who were really arguably economically were the correct plaintiffs and not consumers. But he read the Clayton Act Section 4 literally and said that these folks are claiming they were aggrieved and they were the direct purchasers. They paid Apple directly, even though Apple was viewing itself only as an intermediary, that they were really paying the developer. But I don't think at the end of the day that case is going to get very far based on a monopolization claim, because the retail app market is much broader than just the Apple apps. In Manhattan Community Access, he decided that, as you can read, that the operator of a public access television channel was not a state actor. Obviously, the free speech clause doesn't apply if you're not a state actor. This is one, as I put it in my paper, this is the case of an umpire calling balls and strikes. My strike zone may be a little different than your strike zone, but here where government does not traditionally operate television stations, that means that this was not a state actor. Not clear yet what his views are on stare decisis or on the death penalty. We learned a little bit, as I mentioned before, on Roe v. Wade in the June case. I think he would modify Chevron. Maybe he would. It's hard to know. We just haven't learned enough in all these areas to make a determination. I do think he probably is not quite as conservative as some people think, but he's also not Justice Kennedy, because Justice Kennedy thought partisan gerrymandering may well be justiciable, and obviously he took a different view. So the jury's still out on him, and we'll certainly learn a lot more in this coming term. Why don't we try? We've got about 8 minutes left, Ruth Ann. Why don't we see if we can, instead of doing 11 cases in 11 minutes, let's see if we can do 11 cases in 8 minutes. And so
You're ambitious.
Lamps Plus held that if there's ambiguity in an arbitration clause over whether or not class actions are permitted, that Stolt-Nielsen still applies. There isn't a showing of consent and class action isn't permitted. In the Shine case, the wholly groundless exception that some courts have decided to deal with arbitrability was found not to be applicable. It's not within the Federal Arbitration Act, and the standard remains whether or not the arbitration clause clearly and unmistakably gives the arbitrator the right to decide arbitrability. Wholly groundless is no longer an argument that somebody can make to defeat a motion to commit to arbitration. And New Prime involved a transportation worker, and the Federal Arbitration Act carves out an exception from arbitration for transportation workers. And so even though it was an independent contractor, Justice Gorsuch wrote the opinion that's deciding that indeed, because the arbitration clause was in the transportation industry, it wasn't applicable under Section 1 of the FAA. So I'll look at the question, Ruth Ann, while you take on the next one.
Okay. We had 2 unanimous employment decisions. In Mount Lemmon, the court held that the numerosity requirement that defined employer to be those with 20 or more employees in the Age Discrimination and Employment Act did not apply to a state or political subdivision. This was an 8-0 decision that rested on Justice Gorsuch's careful statutory analysis. And then in the other, Justice Ginsburg determined that Title VII's requirement that an employment discrimination claimant must file a charge of discrimination with the EEOC as a precondition to filing is not a jurisdictional requirement, and thus it must be timely raised as a defense or it's forfeited. You can ask Bill questions about that later, he says. And another unanimous decision in the class action context, the court clarified that Civil Rule 23F, addressing appeals of class action certification decisions, is not subject to equitable tolling. Rule 23F permits the Court of Appeals to grant an immediate appeal of a district court's order granting or denying class certification if the party seeks permission within 14 days. While Justice Sotomayor concluded that the rule was not jurisdictional, she went on to hold that the text itself left no room here for tolling. There are still some questions left open here about when the 14-day clock starts running and the effect of a motion for reconsideration, but those questions have for now been left to the lower courts.
Let me just quickly answer the question that's been asked by William Madden. The percentages of eight or 9 votes is the question. Is this higher or lower than prior years? Last term, it was 50%. In 2016-17, it was 55.7%. Going backwards, 53.1, 50%. And the high water mark for the Roberts Court was 2013-14 when it was 63.5%. So the trend line is down on unanimity. And what's the explanation for that? I think it's certainly the change in the constitution of the court. Obviously, case selection plays a role as well, but it takes 4 votes to grant cert, and I think you're seeing a reflection of a more conservative court taking on some cases and less unanimity as a result. Let me quickly go through a couple of these cases. The FOIA decision. There were some cases that have held that I can get information that you provide to the government unless you can demonstrate that there would be a substantial substantial competitive concern. And Justice Gorsuch said there's no such language in the statute, so that indeed that standard does not apply. It's inconsistent with FOIA. And this was a case where information had to be submitted to the government. So you don't have to prove substantial competitive harm to prevent public disclosure of the information. And the Fourth Estate case was a copyright case where the court held that registration of a copyright occurs when the Copyright Office registers the copyright and not when application is made. But recovery for infringement covers the time both after application and after registration. Ruth Ann, what was Air and Liquid Systems about?
This was a really interesting case in which the Supreme Court was sitting as a common law court in the area of maritime torts. They were looking, and as with opinion on the scope of the duty to warn in maritime torts. The question was, the defendants were manufacturers of different equipment that was used on Navy ships, and all of the equipment required asbestos to function as intended, but the manufacturers themselves didn't install the asbestos. It was put on after the equipment was installed on the ships. And the question was whether those manufacturers had a duty to warn of the dangers of asbestos. And so, the court then kind of laid out the standard that would apply in these cases. And what's interesting, and I think we'll see in the future, is what impact this is going to have on other common law courts and whether they're bound by it or not, how state courts, federal courts looking at common law torts are going to look to this opinion. And interestingly, I just checked this morning, and there are already both state and federal courts that have cited the DeVry's opinion to at least look as persuasive effect and given it a lot of attention as to what the duty to warn might be in these types of circumstances. So I think you will continue to see it cited in cases outside of just the maritime tort context.
So in the Merck case, a preemption case involving a change to a drug label and whether or not the FDA would not have approved it as a defense to a state common law claim against a drug manufacturer, court held Justice Breyer writing the opinion that clear evidence has to be shown that the FDA would not have approved a change to a drug label, but a court, not a jury, makes the determination of whether clear evidence exists. And then the securities law case, Lorenzo, the question was whether or not dissemination of false or misleading statements with intent to defraud represents, quote, making false or misleading statements under Rule 10b-5. And the court held that indeed it did. And let me just say something quickly on the 2019-20 term bill, then I'll let you wrap up. The fate of DACA is obviously going to be a key issue. That's the Deferred Action for Childhood Arrivals policy. The Department of Homeland Security decided to wind it down. And then the application of Title VII to discrimination on the basis of sexual orientation is going to be front and center. The New York City handgun case may be mooted, and there are a couple of major environmental decisions that are before the court as well. And with that, Bill, I'll turn it over to you to wrap it up.
Well, thanks so much, John and Ruth Ann. Truly extraordinary presentation. So clear, so impressive. Thank you so much. If anyone has questions in addition to those raised during the program, please feel comfortable to give any one of us a call. Thanks for sharing your knowledge, John and Ruth Ann, and your insights. I think we all, as lawyers, are ever thankful to your extraordinary insights. And frankly, in today's environment, the role of the judicial branch and the legislative branch and the executive branch, I think, are ever more prominent, those key roles in our thinking. And as John said, our constitutional democracy, as he mentioned, is really at work and at work for the benefit of all of us. So thanks so much, everyone. Wishing you a wonderful weekend. Appreciate you joining us so very much. Concludes our program.